Hi, welcome to mediatorpodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gragg, and I'm a valuation expert and divorce financial mediator in St. Louis, Missouri. I am talking to Beth McCormack today, and she's a divorce and family law partner at Beerman LLP in Chicago. When you're going into this and you're kind of developing this strategy, are you always talking to people about mediation as a possibility? Because even as you talk, I'm like, I could see how collaborative law could be a really good thing because you're kind of locking in the privacy, you're locking them into the, because in my mind, I guess, when you leave collaborative, you would have to hire a whole new team. That would be like a big cost to keep them in. So are you seeing them like collaborative or want mediate? Because mediation is kind of the Wild West. So we have more control over doing things in mediation. But is there a role for collaborative in this process too?
I would say there's definitely a role for collaborative, but I have a really, really tough screening process for obvious reasons. For those listeners who don't know, if you're not successful in a collaborative law matter, you start over with all new counsel, all new valuators, et cetera, et cetera. That is a motivator often that just keeps people at the table. That alone keeps people at the table, which is sometimes an added plus for collaborative law. Sometimes not. I have clients who are like, there's no way I'm signing a participation agreement if I lose you. And I'll be like, but there's other great lawyers that are, so I personally believe collaborative law is appropriate in ultra high net worth matters because you're promising to one another, committing as a team member to problem solve at the table, to not threaten court, to not talk about having a judge come in and tell us something. We can figure this out. We're smarter than anybody here because we know our family and we know our business and we know our values and our priorities. So I offer all options to all clients. We have a duty to do that, I believe, as lawyers. I'm not going to sit here and tell you litigation, collaborative, or mediation. Sorry.
That's okay.
Um, I do think clients need to be told what all the options are and they get to weigh the pros and cons to each. So I think a billionaire divorce and a collaborative matter, I've done many. I think that can be very helpful. But knowing that if they're not successful, they're starting over completely. And I have one case in particular that it's like anything in life. Once they failed in collaborative, I've had one failure, which is all about the screening.
Right.
And once they failed, they litigate every decision, and it's horrifying emotionally. They can afford to litigate. Of course they can litigate. But emotionally, they have just destroyed one another. And that in turn obviously affects the children.
Well, and how often, because, we had a situation and, it was a pretty difficult situation. We thought we did a really good job at prevailing, and it was through kind of mediation through the court system, like in tandem with trial dates and things like that. And we got to a situation where we thought the client got a tremendous amount of cash, right? Not stuff, but actual cash. And that's what we always want to get. And this particular client literally left the courthouse sobbing, like just crying. Like it was the worst thing that ever happened because she didn't get any of the things. And, looking back on it, when we talked to the narcissistic coach and they said, you didn't do one thing. And I was like, what did we not do? And they're like, you should have worked on unattaching the person from the stuff, from the jets, from the cars, from the boats and the houses and things like that, because she didn't see it the same. She didn't see the cash the same as the stuff. So do you see that you're getting in a situation where you're having to bring other therapists in? Because a lot of times they might have their own therapist.
Okay, Melissa, I do not represent clients who don't have a therapist or a coach. No. And I'll give you a real life example as to why on that and why they also have to have a financial advisor, an independent wealth advisor. So I worked with a woman who was getting $50,000 a month. I did not represent her in the divorce. This is what's called post decree. She came to me because she was running out of money. No one spent a minute with her explaining why her lifestyle did not allow for her to have $50,000 a month. It was a great award of support. To most humans, it's astronomical.
Right.
And the lifestyle they had acquired, it didn't come close to meeting her needs, but no one talked to her about that. And back to your point on detaching from stuff, in this particular case, she wanted that family home. Well, it had carrying costs alone of $35,000 a month. Well, that doesn't leave a lot for handbags and travel,
Right.
but no one talked to her about that, to your point, as a coach or a therapist, and more importantly, a financial advisor.